I think you're going to really enjoy this panel. It's titled Making the Best of a Bad Situation, How to Implement the Best Practices of Portfolio Monitoring. We have three distinguished colleagues up here. You've seen them before. Just introduce them one by one. First, it's Serena Hallowell from Motley Rice. Sitting in the middle, moderating, is from our hometown, Harry Griffin. He sits on the San Antonio Fire Police Pension Fund. And on the end, it's Adam Savette from Levy and Korzinski. With that said, I'm going to let you guys take it over. Thank you all.
All right. Well, I didn't expect to be sitting on this bar stool with all those lights. It's pretty bright in here. Before I begin, and I wanted to do this on Sunday, and I just didn't have the opportunity to do it, but let me take a point of personal privilege. We had I guess they call it a delegate bylaws meeting Sunday, and I was in that room and glanced around the room, and all the members and delegates of TEXPERS that represent public pension plans were in that room. I looked around, I only recognized maybe a dozen people that I even knew. There's so many new people. I've been on my board for 31 years and been around this system for 31 years. And I walked over to one of my fellow board members, and I see him sitting there in the back of the room. I can barely see him because of these lights. Larry Reed. I said to Larry, Larry, I think you may be not in age, but as a member of TEXPERS, and I believe you were one of the original members of TEXPERS when it was formed, the oldest board member, not a Texas board member, that's attending this meeting. So I'd like to, and I think you are, and I just like to make a point of recognizing you. Larry's in the back of the room. Larry, if you stand up real quick. I think everybody knows you, but I think you're the most senior member of this group, and I wanted to do this on Sunday. Larry, I think I'm in the top 5, so it means both of us are old. So anyway, I'm Harry Griffin, a board member with the Fire and Police Pension Fund in San Antonio. I'm a retired police officer, was the assistant chief of police when I retired in 2010. It's been a great ride to be a member of this system and watch it grow and see all the great benefits that it provides. The plan participants of the Fire and Police Pension Fund in San Antonio. We were a $340 million fund when I first became a board member. I believe when Larry became a board member, it was less than that, maybe in the $100 million. It's grown to $4 billion today, and a lot of good things have happened. Benefits have been improved. We've learned a lot, made a lot of changes in our investment themes and the way that we practice and try to protect the pension fund assets. And this is one of the ways that we do it. With law firms that are security litigation law firms that help us if fraud's perpetrated against investments that our investment managers might make. And it was probably 10, just to give a little history, it was probably 10 years ago, maybe 15 when we hired our first firm, and now we have multiple firms, and we'll talk about that in the presentation later. But it's been important to us, and I just mentioned just one thing real quickly, and I did this I think maybe a year ago at a presentation like this, and I asked our staff, I said, what's the value just in dollars of the monies we recovered that have been recovered as a result of securities litigation? And if I remember, and this was as of a year ago, $1.8 million to the Fire and Police Pension Fund San Antonio in a variety of cases over the past year. So that's real money. If there's, if you want a reason why you should do this at your pension system, and if you're not doing it, there's one good reason right there. There's a multitude of cases from $100,000 plus recoveries, and if I remember right, seeing the spreadsheet down to recoveries that were like $75. But add them all up, and over 10 years, it's 1.8 million. So anyway, just one good reason why you should get involved in this. Let me let our panelists kind of introduce themselves. I'll start with Serena and kind of tell you a little about themselves and a little bit about what they do at their firm. Then I'll do the same thing with Adam.
Hi, everyone. Very happy to be here. My name is Serena Hallowell. I'm a partner at Motley Rice. I've been practicing for almost 20 years, primarily in the area of securities litigation. Motley Rice is a a plaintiff's firm that specializes in complex litigation of all kinds, and we have offices all over the country, and we represent investors and plaintiffs globally.
Adam?
Adam Savette, I'm the Director of Communications Institutional Research at Levy Korsinski. I've been a securities litigator for a little over 2 decades, not that anyone's counting or bragging, Serena. We are a hyper-focused securities litigation firm. It's essentially all we do. So we have public fund clients, private institutional clients, Taft-Hartley clients, and we try and help them recover what they've lost due to fraud or mismanagement.
And as we continue, if we raise an issue that you'd like us to address, just, break us at any time. We'd be more than happy, to address it, and we'd like this to be interactive if possible. So if we can see your hand with these lights, but just reach out to us if you do have a question. Let me just give a little more background, and I'm going to ask the panelists a few questions that I think are timely in this area. But back to when we were considering doing this, there was a lot of discussion amongst our board, wondering if there was any value, in this. And I can remember discussions at some board meetings, even with another, police trustee, and you would think the police would get this. When you're defrauded and there's a potential to get a recovery and get money back for the plan participants, you ought to do it. You have a fiduciary responsibility to do it. But it wasn't that easy. I remember, one of our board members said to me, he said, well, Harry, you have to be able to, accept market risk. Well, this isn't market risk. These are sometimes crimes. These are frauds, unethical dealings that cause, some security that you own to go down in value that's recoverable through a firm like one of the two that are represented here today. It's not market risk. It's fraud. Completely different. Market risk is when Russia invades the Ukraine and the markets go down. That's market risk. That isn't the kind of risk that we're going to be talking about here today. So I think it's important as a fiduciary that if you're the victim of fraud in an investment that's in one of your portfolios, that as a board member, that you try to do everything you can to recover as much as possible. So from that, we hired a firm, and over the years we've got multiple firms that work for the Fire and Police Pension Fund. So that kind of leads me to my first question: is one firm the right number? And we don't think it is in San Antonio, but is there a reason to have more than one firm? And does it make any difference if your fund is a $50 to $100 million fund with size of your investments, or if you're a $5 billion fund? And let's turn it to whoever who might want to address that.
Well, I can start, and I'm sure Adam will follow on. I don't think that there's a one-size-fits-all in terms of this answer. I mean, we have clients where Motley Rice is the only firm monitoring for them, and I'd say if it's my firm, then yes, one firm is enough. But for the most part, I think most of our clients have multiple firms monitoring for them. I think some of the benefits of that is, for a variety of reasons, you may not get apprised of a particular litigation or from one particular firm, right? Maybe they're conflicted out, or maybe it's not on their radar. If you have multiple firms that are monitoring your portfolio and seeing when you sustain fraud-related losses, then you're getting more information. And to a certain extent, more information is always better. However, you have to balance that against your size and your resources. You don't want 20 emails a day, and you don't want to read, a ton of quarterly reports from us, even though we think they're great. Like, it does take some time. So I think you kind of have to balance your constraints and also figure out what you want out of the process.
I mostly agree with what Serena said. There's sort of one giant overarching theme that sort of should be put out there. The services that securities litigation monitoring firms offer are done at no out-of-pocket cost to the client. It's free to you. So at the end of the day, why wouldn't you take an additional free look at your portfolio? That's kind of my question to most clients when they're sort of looking at this area. And Serena has some answers. Well, too many is too many, and you don't want to be inundated. But realistically, having just one, even if it's just my firm that's doing it, is probably not the best fiduciary duty plan out there. And there are a couple of pretty straightforward reasons why. One, differences of opinion. If you have 5 firms monitoring your portfolio, and we tend to advise most clients, even if they're tiny or huge, 3 to 5 is kind of the nice part of the bell curve to be in. But you want to have 3 to 5 firms telling you, this is a good case, it's meritorious, or this is a crappy case. You shouldn't touch this with a 10-foot pole. And if you get unanimity of opinion, that generally tells you something. You know, our firms, we operate on a contingency basis. We don't get paid unless we recover something. So we're a business. So we tend to only suggest to our clients that they proceed in cases that we think there's a reasonable likelihood of recovery. Otherwise, we're not going to get paid, and we're not a charity, so we're not interested in that. So if you have all of the firms saying, yes, this is a good case, then that merits some attention. It merits you taking a harder look at it and deciding, yeah, we should be interested. There are other areas, though, where you might have differences of opinion. Serena's firm might recommend a case, we might say no. And it could be because we have done a particularly deep dive on that case, or because Serena's firm has expertise in that case and they see something that we didn't see. So that's also important. If you have differences of opinion, then you want to bring everyone in, either virtually or in person, and say, pitch it to me. Why is this a good case? Why is this a bad case? And again, you're going to get more informed. And ultimately, yes, you don't want to be like, there's one public fund a little bit north of here in a different state that has 12 or 14 firms. That's too many. I will unambiguously say that out loud with words. 12 or 14 is just too many. You're going to be too inundated with stuff. But having multiple firms, it's a good thing. There are times, though, and there are services where you only need one service provider. So going all the way to the end of cases, for claims filing, you only need one service provider. You can only have one service provider. And that's an important thing that we'll kind of talk about a little later on.
Just to add on to Adam's point, there are certain firms that will maybe focus on certain types of securities litigation more than others as well. So for example, our firm, I head up our opt-out or direct action practice, right? Other firms are not as focused or interested in opt-out or securities direct actions. Non-US litigation is, increasingly something that we're seeing out there in countries all across the world, but some firms focus on that more than others. And so to cover your bases, you do want to have, I think for the most part, more than one firm.
2 things you reminded me of, both Adam and Serena. Each of you brought up kind of a different point, and it's things that we considered when we were deciding whether to do this or not. What does it cost? What's it going to cost us in the way of dollars? Well, Adam said, it doesn't cost you anything, so why wouldn't you do it? It costs $0 to have one of these investment firms monitor your portfolio. I'll get to you just 1 second. And then Serena, the thing that you mentioned before I forget it, and I think that was one of our greatest concerns, because I don't know that we had general counsel on staff when we hired our first securities litigation firm. We had outside counsel, and we have general counsel now for the last maybe 8 or 10 years. But we were wondering and had thought that this is just going to take a lot of our time, and is it worth it, all the time that it takes? And and we've come to learn it doesn't take a lot of the staff time. In fact, we had that discussion in executive session just maybe a month ago, and we asked that question of our general counsel who's on staff. Is this overburdensome? Is it taking a lot of your time? Because we have 5 firms that work for us, and she said no. It's totally worth the effort in making sure that we're not the victims of fraud, and hearing from firms like yours that there's ways to recover, and the proof is in the pudding with the $1.8 million that we've recovered just for our fund alone. So yes, sir, you had a question.
Can you give us some examples of the cases that were involved where you got the money back?
We talked about that a little bit yesterday. Adam and I did, and have you got a case that you could bring up that's that's not really all that complex, that maybe some of the facts and
sure.
what resulted there, and how the pension fund was able to recover?
Yeah, so one of my favorite cases to discuss, it was an optical networking company. Optical networking, that's kind of all the parts and pipes that go into you being able to access data on your cell phone or your Wi-Fi at home. They were a very large publicly traded company. They started to fall behind their competitors, but they didn't want to tell the street that they'd fallen behind their competitors because obviously their stock price would take a hit. So what did they start to do? Okay, first thing they did was they would channel stuff. So channel stuffing is when you send your distributors and your retail partners too much inventory. So you send them 2 quarters worth in 1 quarter. That works short term because you're still hockey sticking, right? You're wow, they're showing great growth. Problem is you rob Peter to pay Paul, so now Q2, you have a deficit already because you already sent the Q2 product to your distributors. So they had to get even more creative, okay? We can't just channel stuff anymore. Okay, we're gonna drop prices. We're gonna offer rebates. We're gonna do all sorts of things. We're gonna offer rights of return that only take effect just after the quarter closes. So we can close our books in Q2, and then Q3, we're gonna get all of this crap sent back to us. That still wasn't enough because again, if you're robbing Peter to pay Paul, and you keep doing that quarter after quarter, it just keeps getting worse. You know, rule number 1, when you're in a hole, stop digging. They didn't do that. They just kept digging. They asked for a bigger and bigger shovel. So now they've channel stuffed, and then they've offered rights of return that were way beyond what anyone else in the industry was doing. So they are so far down that they're never going to recover. But they double and triple down. Okay, what are we going to do next? We're going to make things easier because we don't like processing the returns. So we're going to set aside part of our shipping yard, and we're going to call that the ABC distributor part of our shipping yard. So we're going to have our shipping company take this tractor trailer from over there and move it over there. Now it's ABC's. So we're not even literally going to send the product to them. It doesn't even leave our warehouse yard, but we've attributed that to them, so now it's going to count on their books. We're not even going to tell them that we've done that. So they now were lying to their own distributors. This is how bad things are getting, okay? So now they're shipping stuff across their yard to their distributors who don't even know that they have it on their books because they never told them it's on their books. Eventually, some of the distributors find out because they go, wait a minute, we've read your financials. We're on the hook for $25 million in product that we never took from you guys. Where is that product? Oh, don't worry, we moved it back to the other side of the yard. You guys aren't on the hook for it. But now they've fallen so far behind all their competitors that, and I apologize for the length of the story, but it's near and dear to my heart because I spent 3 years on the case. The fraud just kept getting better and better, at least in my eyes. So now it was so bad that they decided, you know what, and I apologize for language, they said, we're just gonna ship the shit. They knew the products didn't work at this point. They were so far behind, they didn't do what the clients needed, but that was their term of art inside, ship the shit. So they would put stuff on the trucks, they would move it across, or sometimes even get it out of the yard, and it didn't work. They knew it was coming back. So at this point, the fraud has grown to X level. And then the next step they took, which is by far my favorite part of the story, they just started putting bricks into the boxes. So they weren't even shipping the shit anymore, they were shipping bricks at this point. And of course it crumbles like a house of cards like you'd always expect. Ultimately, the recovery to the class was $678 million, which was a fraction of the losses. And that's a function of how this business works. We generally can only go after viable assets. The most viable asset is the insurance that publicly traded companies have, their D&O insurance. Typically, even for a large public company, it's $150 to $200 million at the top side. If you're in a really risky industry, you may have a lot less than that because it's too expensive. We typically can't go after the directors and officers because even though they've gotten paid along the way, they don't have sufficient assets to actually make it worthwhile, except in certain egregious cases to go after. If there were public offerings, we can go after underwriters. But we don't want to bankrupt the company because often our clients, even though they were defrauded when they bought it, they're current shareholders now still. So if we bankrupt the company, we're hurting our clients. We're not helping our clients. So there are limitations on what we can recover. So there is some market risk that you have to take, but we try and get as much back as we can. And I apologize for the length of the story, but.
Similar one?
Another case?
Yep.
There's I'll be brief, but there was a case against an oil company, a Brazilian oil company called Petrobras. There was a multi-year, multi-billion-dollar bribery and kickbacking scheme that came to light publicly. As a result, there was a class action filed in the United States, and the settlement in connection with it was close to $3 billion, which is a really large settlement. definitely had clients that got checks that were in the $1 million range just because of the size of the losses. And so to Harry's point from earlier, you definitely can get sizable checks in connection with these class actions. What I think is interesting about it is that in addition to the class action, there was dozens of opt-out and direct actions filed by institutional investors, asset managers, hedge funds, public pension funds that also resulted in confidential settlements. And there's also a non-US litigation that is still ongoing where there were certain securities that weren't covered in the US. And so in order to protect investors' rights, they had to also pursue litigation outside of the US to cover for losses sustained in the non-US securities. And my firm represents some of those investors right now. But it's a good illustration of sometimes the class action may not be the best mechanism for you to seek recovery for your losses. And so you also want a law firm who's going to be able to advise you of all of the different strategies or opportunities there are to recoup your losses, whether the securities that you hold are even going to be covered in the class action, or whether you need to consider an opt-out or a non-US litigation.
And just real quick, and maybe either of you can maybe add to this or correct me if I'm wrong, but I remember a case that we dealt with actually at our fund over the last couple of years where it was brought to our attention by one of the securities litigation firms that we were, investors in a stock where the decision makers at the firm, the CEO and the board of directors made some kind of a decision to have different categories or classes of stock, or maybe a stock split. I'm not sure exactly how it happened, but I know it was different classes of stock. And we got, as an investor, the pension fund, got the class of stock with all the warts on it and all the hair on it and all the problems, and they got all the good stuff. And our value of our stock dropped pretty tremendously, and that's what caught the attention of the securities litigation firm. I don't know if you've heard of cases like that, or maybe you know of this case. I can't remember the name of the case. And but situations like that are pretty damn obvious that you ought to pursue those, and if you've had losses.
Yeah, we were involved in that case. It was against a little company you might have heard of called Google. They tried a share reclassification scheme where the founders would get the non-warty stock and the public investors would get the warty stock. Ultimately, the payout to the class was about $622 million, and then because they nullified part of the reclassification, there was an additional benefit of about $3 billion back to the class. So, but absolutely, that's one of our core practice areas, are sort of looking at every proxy statement that's filed and every transaction that's proposed to sort of say, is this fair? Have the dealings been open and honest? Are insiders getting more than the rest of the public shareholders? And we aggressively go after that and attack transactions where there are clear conflicts of interest, where the premium that's being paid in the transaction, it doesn't match with what the market suggests it should be. It's part of our duty on behalf of our clients to make sure that they're not getting screwed in any way other than the traditional stock drop fraud. If insiders are looting the company, then you as a shareholder have a right to go after them and try and recover.
So let me move to a different question. I'm looking here at the title of our topic this morning is how to implement best practices for your portfolio monitoring. So we've had this issue kind of confront us in San Antonio. We've got multiple law firms working for us in this area. So what's the best way to select, if we've got 5, to select one when all of them are recommending the same case? How would you advise us on that if you were working for us?
We have different clients who, again, employ different strategies on this. Some of them do like a straight rotation. It's your turn, you're up, for fairness sake, and because presumably if you have someone monitoring for you, all of the law firms are qualified and know how to litigate these cases. We have other firms that have said, other clients that have said, it's whoever comes to us first, that's that was their response to, making sure that it's kind of fair. If you have a little more bandwidth, sometimes, and you're particularly interested in a case, sometimes it makes sense to do a beauty contest. If 5 firms send you, a notice about a case saying that they like it and they recommend you pursue it, ask them, like, what's their strategy? What do you bring to the table? Why you? Why not someone else? I have one of those this week. And not that they're not all great firms, but at times, certain firms do bring different things to the table, right? Maybe they have a lot of experience in front of the judge. Maybe they're really great at litigating pharmaceutical cases. So different cases may benefit from different counsel.
I would agree that each situation is going to be a little unique. I would say, from a fiduciary standpoint, the most important construct is have something in your policy that addresses this up front, so that there are no even appearances of impropriety, that, wow, Adam's firm or Serena's firm always gets the work. No one ever seems to get it other than them. Just make sure that it's clear and unambiguous up front how you're going to do it. If it's always a beauty contest, then it's always a beauty contest. If it's a straight rotation, then that's fine, it's a straight rotation. If you want to do it some other way, first in time, then make sure that everyone on the board knows that, make sure your GC knows that, make sure that your outside firms know that. I tend not to be a favor of the first in time rule, just because it makes everyone rush. And so I'd prefer to have a more thoughtful, in-depth analysis of a case that I can do and give to a client. Because sometimes at first blush, it's not a good case or it's a great case, and once you dig a little deeper into that onion, no, it's really not as good, or yeah, it's much better than we thought. So there is some time constraint involved. Once the first case is filed and the notice goes out, you have 60 days to decide if you want to go forward. Saying you want something on day 1, that's probably not the best policy. But waiting until day 59, probably not the best either, because you want to make sure you have enough time to digest all the information we're going to give you and come up with an informed, reasoned decision either to go forward or to not go forward.
And in talking last week with Adam, and I kind of broached this topic, and he mentioned it ought to be, is it in your policy? And I thought, I don't know if it is or not. And so we had a board meeting just this past week, and I asked our general counsel, I said, hey, we've been confronted with that issue. Is it in our policy? Do we have something, at least some guidance? And she wasn't sure, so she's looking into that. If it's not, I think that's a great point that you've made, and it ought to be something, it doesn't have to be where it just completely binds us to, to one way to handle this, but at least there ought to be something that addresses it, so that when we're confronted with it, we've got some guidance in that. So I guess on the flip side of that, that question was, if you've got, multiple firms come to you, almost in the same week, saying that you ought to pursue this case, how do you select, which firm do you pick? Well, the flip side of that is, and we've had this happen just in we dealt with this just last week. We've got 5 firms. We got 4 that say, no, we don't think this is worth pursuing. And we've got 1 saying, we think this is a great case, you ought to do it. So, do you go ahead and take the case? What do you do? What's the fallout if you lose the case? I've got questions like, is there any reputational risk? What would your recommendations be if a pension fund was in that situation where they've got multiple firms saying, we don't think it's worth it, it's not really that good of a case, and one saying it's really a great case, you ought to do it?
When we recommend cases, and I'm sure Adam's firm is the same, we send detailed memos out, telling you about the case, what it's about, and then also making a recommendation. Letting you know what your losses are, and then saying, we think you should consider lead plaintiff in this situation for XYZ reason, or we think you shouldn't consider it, and here are the reasons as well. So to the extent that your firms are doing that, the memos, should kind of lay out the rationale for why they're recommending not to pursue it. I would say if 4 different firms are recommending not to pursue it, there's some issues there. But I would also just call up, the different firms and ask them, like, why, someone is recommending it, and here's their rationale for why, and kind of utilize the deep bench of law firms and legal expertise that you have to kind of talk through it.
Yeah, in terms of sort of why 4 might say no and 1 might say yes, part of it is just their client roster. So if we look at our clients and San Antonio has the largest loss out of any of our clients, then we're probably going to approach them as long as it meets their thresholds and their policies and say, hey, look, this is a meritorious case. And it could be as simple as that. It could be that the one firm that's recommending, they might not have clients with larger losses, whereas the other 4 firms might have clients with larger losses. Sometimes it's as straightforward as that. Sometimes it is. They have unique insight into the case. But sort of to go back to your original question, which is reputational risk if the case goes south, I'll talk about a case that didn't go south. Show of hands, who thinks that they remember the lead plaintiff in the largest securities fraud class action settlement of all time, Enron? $5 if anyone can name the lead plaintiff that's not a securities litigator. Who's the lead plaintiff? Who was the lead plaintiff in Enron? $7.3 billion recovery, largest securities class action settlement of all time. Reputationally, I mean, obviously it wasn't, the case didn't go south, but nobody knows. It was the University of California Regents. But that's the reputational risk, and I'm not making light of it, but I'm just pointing out that there really is very little reputational risk in general. Is it zero? No. If you're suing a company that's large in your own backyard, there's obviously reputational risk because an investigative reporter might dig into that. There was, a situation up north where someone was inadvertently or accidentally added to a complaint that they hadn't authorized yet, and it was a company that had large local ties, and there was very quick public backlash. So that could happen, but that was an accident. That's not the norm. So it's not a zero reputational risk, but it's quite low, especially if it's a well-vetted, well-run case. Look, I've had cases over my career where a client comes to me, and I think it's a slam dunk. Great judge, great circuit in terms of what the law is there, great set of facts. Case just gets dismissed and affirmed on appeal. I've had terrible cases where I begged the client not to proceed, and they settled for tens of millions of dollars. It's not quite a casino, but there is something of a you don't always know what's going to happen. I think Klausner said it yesterday. Anyone that tells you it's better than 50-50, run away from them. There's some truth to that. We can tell you it's a meritorious case. We can't tell you there's a 100% chance you're going to win and recover 100 cents on the dollar. If we ever say that to you, smack us and run the other direction.
You just brought up something, this reputational risk issue, and we've discussed this at our board as well. So can a pension system run into kind of getting a black eye of being looked upon negatively and have reputational risk because they bring every class action case that they're ever, they're like they're a $2 billion, let's say they're a $1 billion plan and they bring 15 a year. Does that happen, or is it, I'm probably exaggerating the numbers, but can you be looked at, I guess, by the courts or by other decision makers that you're just constantly trying to sue?
Defendants can, and do from time to time try and paint institutional investors to pursue these cases as serial lead plaintiffs. To me, it's nonsense, and courts don't pay it much credence. I mean, the whole regulatory system is set up so that institutional investors like yourselves are leading these cases because they bring back better results for the class as a whole. And so, I don't think that there's much that defendants can do with that, but it is raised.
I guess I would gently say there is no amateurism rule in the courts. You don't have to be a newbie. In fact, having a seasoned plaintiff client by my side gives me additional comfort that I know that they are going to understand each step along the way, that they are going to be an involved partner as we continue on the path. Congress in their infinite wisdom decided that institutional investors should, all things being equal, lead these cases. That's the PSLRA in 1995. And there's an actual carve-out because there is a professional plaintiff rule in that law. But there's an express carve-out for institutions that says, oh, no, you can waive that for institutions. You can't waive it for retailers. but you can waive it for institutions. So, look, if Congress says that's the law, then that's the law, and we have to run with it. You know, as Serena said, look, defendants are going to tar and feather you no matter what, or at least try to, but the courts aren't necessarily going to ever do that. They're going to say, exactly as I said, that, look, this is a seasoned, well-intentioned investor who has significant losses. They have stake, they have skin in the game. Why wouldn't you want them involved?
So, quickly, can you speak to like shareholders' rights cases? You know, there's, in those kind of cases, I understand, like there's not a recovery in the way of damages for you know, a pension system like ours, but you change like what are the business practices of a company that makes it better for the investor. Can you kind of talk to that just a little bit, why that's important and why a pension fund might want to be involved in a shareholders' rights case?
Sure. So there's the typical class actions that we've been talking about where you sue a company for their misrepresentations or omissions primarily, and you get damages back. You know, that's the recovery. There's other cases primarily pursued in Delaware, though not exclusively, where you're suing derivatively or on behalf of the corporation because their directors and officers have maybe breached certain fiduciary duties or kind of fallen asleep at the table and aren't protecting the company. And so you step in and as an existing shareholder seek to protect the company, and these largely involve corporate governance reforms. So you're seeking to change something at the company in order to make it stronger, better, to help the share price down the road. And so, as Harry said, these cases don't necessarily put money back in your pocket immediately at the time of settlement, but if you are a long-term shareholder in a particular company, corporate governance reforms oftentimes leads to a rise in the share price. So over time, you do actually benefit from participating in these cases. In addition, sometimes there may be a particular issue that's important to your fund. ESG, comes to mind. Maybe you're very focused on environmental sustainability, or you want to make sure that there's no workplace harassment, or there's a number of issues that are important. So you then get an opportunity to enact positive change in those areas.
And sometimes it's as simple as attacking a proposed transaction or a change to bylaws or things of that nature, where you as a continuing shareholder in the company, you're going to suffer an ongoing harm because they're taking away your voting rights, because they're diluting your voting rights, because they're giving excessive compensation to insiders. Yes, you may not directly get dollars back or pennies back, but you're avoiding that ongoing harm. So it is important, even if you're not a police fund like Harry, you get to be the sheriff of Wall Street. You get to kind of help make sure that that sunlight's acting as a good disinfectant, and that you're making sure that companies are doing the correct, right, proper thing, and that you're calling them out when they're not.
Okay. Kind of the last question I had here, and we'll open it up to questions again here in a minute. And we see this in San Antonio, and it's a relatively kind of recent development. We're seeing that, a firm like yours will come to us, that one that represents us, and they say, we'd like you to combine your losses with another pension fund, and often it's another Texas pension fund, because we represent both of your funds, and if we combine your losses, we have a better chance of being lead plaintiff. Is that a good practice? What are the upsides of that, and what are the downsides of that?
I always start, so if you'd like.
Sure, thanks. So again, it goes back to the law that Congress enacted in '95, the PSLRA. In the early days, it was the Wild West, and shareholder firms would gather together, because groups are sort of explicitly and implicitly allowed. They would gather together hundreds, if not thousands, of individual shareholders to try and get the largest loss, because generally courts look to who has the largest loss and when they're going to appoint someone. That practice has largely been struck down by the courts as inappropriate, because if you have 5,000 individual shareholders, there's really not anyone controlling the lawyers. It's the lawyers still controlling the case. And since the law was intended to have it go the opposite direction, it wasn't, effectual. So the pendulum swung to no, just one. And now there's sort of a nice middle ground where groupings are allowed either as long as they have a pre-existing relationship. So if it's 3 Texas funds or 3 Michigan funds or 3 Florida funds and they work together on issues, maybe they have a common outside GC, they already have a pre-existing relationship. They have a structure in place to sort of manage the litigation. That's always acceptable. Or if you have funds that bring 2 different things to the table. This fund has the bonds and this fund has the common stock, so you're bringing different claims together. Again, that's acceptable to aggregate those in. But if it's just 3 institutions who don't know each other out of a police lineup, then courts are still probably going to look at it a little hinky.
There's different reasons sometimes that it makes sense to do it, as Adam said. Maybe you have a particular security and someone else has another security. I also have clients that have never been involved in securities litigation before, and so it's always nice to pair them up with a seasoned institutional investor who has participated, so that they, in addition to coming to us, can talk to them and kind of they get some comfort from having that someone else to talk to, and to make sure that they are fulfilling their fiduciary duties and doing the best that they can for the class.
You brought up an issue, the kind of last point you made. If there were 3, let's say, police pension plans from different parts of the country that had no relationship whatsoever, the courts will actually look at that and maybe look negatively upon that, or?
Absolutely. So assuming that there are competing lead plaintiff motions, so pension group A, pension group B, pension group C all come together. If A has no pre-existing relationship but B and C do, B and C are going to attack A, or at least their lawyers are going to attack A and say, look, this is obviously a lawyer cobbled together group. There are sometimes nuances. So if the lawyers representing B and C also represent A in other litigation, then maybe they won't attack so hard, because at the end of the day, you do have to be mindful of your client relationships. But absolutely, the courts will look, lawyers will always look. Courts will sometimes look, especially if the lawyers point out to the court what's going on. And so, having some pre-existing relationship, and if there's no pre-existing relationship, it doesn't automatically mean it's not kosher. But you generally then need the representatives of those pension funds to come forward with a declaration and say, look, we already have a structure in place. San Antonio is going to lead our monthly conference calls. We're going to have outside counsel. We've already asked for competitive fee arrangements. You just need to show that you're running the ship. And as long as you can do that, then yes, someone may attack you, but it's not going to necessarily be a winning attack.
Question?
Harry, kind of segues off your question. What if this fund over here uses Motley Rice, but then our policy, our rotation, we have another one of our litigation firms who, it's their turn basically, but they also brought it to us. How's that dynamic work between two of your firms, but on basically the same case? Do y'all play nice together like that?
We do. We're friendly competitors for the most part. There are some firms that it's oil and water, but for the most part, we tend to look out for the class overall and our clients in particular. So we try and find ways to work together. Sometimes we can't. Sometimes they're just the economics of the case or the dynamics of the case don't work. But 99 times out of 100, we're going to try and find a way to work together.
It's not atypical for us to be working on, they're large, complex cases, and so, and in order to make sure that our clients are being serviced appropriately, absolutely we work together.
Are there any issues or questions that we didn't bring up that you'd like to ask? Yes, sir.
I have a question. Going back to your example where you had 5 firms telling you this case is a turkey, don't waste time with it, and you got one who thinks it's a great case. Now, previous to that, you emphasized several times there's no cost to us. So what is the downside of going to the one firm who thinks this is a winner and saying, yeah, go for it?
I can answer. I'll give one answer to that. But one of the things that we consider is that even though I don't believe there's an absolute rule on the number of cases that you can have ongoing at one time, that's one of our considerations. And if we don't think it's that great of a case, if we don't want to get confronted with maybe having too many ongoing cases, we won't take it because of that reason. And with the case that was actually that we dealt with recently, another Texas firm was already offering to be the lead plaintiff, and we felt pretty comfortable with that. Maybe it would have helped our chances if we'd have joined, I guess, as the co-lead plaintiff, but we just decided not to in this case. And a year earlier, we had a similar situation. We decided to do it, and we're the co-lead plaintiff with that same pension fund in Texas. So this time we said no. And I think maybe part of the reason was maybe the facts of that case weren't as good as we'd like them to be. And then the other reason was we just don't want to have too many ongoing cases going at the same time. And I don't think there's a limit, but we're told from time to time maybe there is kind of an unwritten limit on the number of cases that you can have.
Yeah, it's going to depend a bit on the judge and the court and where you are. So there's an unwritten limit, but it's more what's your bandwidth. You know, Harry said this isn't a heavy lift, and it generally isn't. Even cases that go to trial, generally there's not that much that's required of the clients, especially when they use only external managers, because there's very little that you would have to say or do that would suggest that you were the one who decided to invest in Google stock or what have you. But there is some time commitment. It's recoverable under the PSLRA, so if you have time and expenses, absolutely, if the case is successful at the conclusion, you can put in for it. But there is some distraction element. Not huge, but there's some.
I think we've run out of time. Yes, sir.
What's the sequence of events of how these cases come to the board goes to the lawyers bring it to the board, what happens there?
I just tell you our experience, and y'all can say if it's any different than this. It's generally our general counsel will bring it to our attention at a board meeting that one of the firms has reached out to them, or multiple firms have reached out to them, and she'll explain, the losses that we've incurred. She'll also explain kind of how it occurred, so that we feel that it's we know a little bit about the case. We may end up doing a conference call with the law firm to understand the case better. So that's kind of the sequence of events is we'll never even know that we've been the victim of a fraud till one of these firms brings it to our attention. It's rare that we know it without them interceding on our behalf.
Yeah, that's generally how it operates, unless you're a mega fund. Certain state level funds, they have a don't call us, we'll call you policy. So they do some sort of internal monitoring when something meets their $10 or $25 million threshold. Then they reach out to the firms that are on retainer and say, hey, is this a meritorious case? Pitch it to us. But normally, yes, we're going to tell you.
Okay, one more question.
Are the contingency fees based on in each case, or is it the same across the board for all cases?
Well, you may have if you bring on a firm, there may be some sort of, you may have specified in the contract with the firm, typically like what it needs to be under X percent, or so there may be some guidance in terms of your particular arrangement with the law firm, but they are based, but then it's also a case-by-case basis, and then those fees need to be approved by the court as well. So the court will look into whether the work justifies the contingency that's going to the law firm.
Make mention about how pension plans, the time that they spend can also fees their time allocated to.
I said that already, Doug.
Yeah. I think Adam said this, but you can also, for any time that you spend on the litigation, maybe you have reviewed some documents, or you sit for a deposition, or you can seek to recoup, put in an application to the court to recoup that time and the money associated with it.
Again, thank you for letting us spend some time talking about this important topic with you. So I think we're done.
Thank you.
Thank you.